Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On this date, the 5th of March 2025, one of the motions in limine that Judge Hippler had put under seal temporarily was released to the public. It is dated February 24th, 2025. It is motion in limine number 5 regarding inconclusive data, and this has to do with some DNA testing. And it notes the first time that Mr. Kohberger's new counsel, Bicka Barlow, who is appearing pro hoc vice, has filed a document in the case. And what this deals with is she is alleging on his behalf that statistical analysis of an item, it's listed as Q13-1. These are fingernail scrapings. There was DNA that was taken from these scrapings, as we read later on, belonged to Madison Mogan. And the testing came back that there was a mixture of 3 persons' DNA, but that it was inconclusive. And there is a lot of testimony on pages 2, 3, and 4 from apparently the grand jury proceedings that are heavily redacted. So it makes it a little difficult to read. But we see the crux of their argument. At the bottom of page 2 is the use of misleading language, that it's inconclusive, might lead the finder of fact, that's the jury, might mislead them, is barred by certain rules of evidence cited here, as well as due process, in that the evidence is overly prejudicial. The erroneous admission of irrelevant and prejudicial evidence will offend due process when it renders a trial fundamentally unfair. And Ms. Barlow cites to Estelle versus McGuire. This is a 1991 United States Supreme Court case. And what she continues to argue is that the idea that the jury could somehow possibly come to the conclusion that if it's inconclusive, well, Mr. Kohberger is not ruled out, and it could violate, therefore, his due process privileges. She goes on page 3 and cites some more about the grand jury proceedings. I think that what's really interesting, if we move on further into this document, is that the defense did challenge this evidence apparently when they sought to set aside the grand jury findings. But what I find really interesting is on page 4, the defense is asserting that Mr. Kohberger disclosed that through further independent testing that he was eliminated as a contributor to 13-1. And when Mr. Kohberger sought to overturn the grand jury indictment, he argued that Miller, this is apparently the person who presented evidence regarding this matter at the state grand jury that returned the indictment against Mr. Kohberger, that Mr. Kohberger had argued Miller's testimony was inadmissible and misleading. The state argued that the testimony was presented to the grand jury as exculpatory, but the independent lab testing conducted by the defense related to item 13.1 is indeed exculpatory, she argues. Mr. Kohberger is excluded and the state should be precluded from misleading the jury in any way regarding this evidence. So they want it in limine, removed from any presentation to the jury this summer. A fair trial is mandated by Mr. Kohberger's federal and state constitutional rights to due process, a fair trial, effective assistance of counsel, and confrontation of witnesses. And so therefore, they argue improperly elicited expert testimony regarding this matter must be excluded. Signed by Bicka Barlow, attorney at law. If you would like to review this document, please follow the link that I have provided in this podcast episode description, and you can read it for yourself. My name's Kathy. Thank you, as always, for joining us here today.